I get a lot of calls where people ask me, the cops didn't read me my Miranda rights. Should my case be thrown out? My name's Piotrowski and I'm a criminal defense lawyer here in South Florida, and I want to talk to you a little bit about Miranda. Now, the only time that a police officer needs to read you Miranda, two things have to happen. One, you have to be in custody. The legal definition is, does a reasonable person in that situation feel like they are allowed to leave? You're having an interaction with a police officer. Do you feel like you can walk off? If the answer to that question is no, then under the law, you're in custody. The second prong to Miranda is, are you being interrogated? Now, interrogation is a police officer asking you a question that's reasonably likely to elicit an incriminating response. So you have to be A, in custody, and B, interrogated. If one of those two things don't happen, the police officers don't need to read you Miranda at all. And that's a common scenario. My first response is, well, did the cops ask you anything? And a lot of the times the potential new client will say no. And I go, okay, well, then they don't have to read you your Miranda. And let's say, just for example, they did ask you a question and you did give an answer. Now, the only remedy to that is we would file a motion to suppress your statements. We could delete those statements from the case, and they wouldn't be able to use those at trial against you, but it wouldn't invalidate an arrest otherwise. So just because a cop doesn't read you your Miranda doesn't mean your whole case gets thrown out. If they violate Miranda, we can move to exclude your statements. If you're facing a legal issue and you need help or you have more questions, click the link below for 100% free and confidential consultation with my office. Thanks, and stay safe out there.